Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me, as always, is Senior Associate from MBK Chapman, Sam Kill. Sam, morning.
Morning, Mike. How are you today?
I'm good, thank you. Good. Sam, as you know, today we're gonna cover AB 130. It's an issue we've covered in prior podcasts. I put a link to that. It's also an issue I've covered extensively in writing. In multiple fact sheets and articles on the website, including one I published this morning. And I will put links to all of those in the description for this podcast, okay?
Okay.
Now, today's episode is not intended to be an explainer about AB 130. We might touch on a couple of parts of the law as part of what we're talking about today, but this isn't what is AB 130, the fine cap, the limitations on fines in California HOAs. We're not here to do that today. We've done that already. You can go watch that episode. Today, we're going to look at AB 130 in the context of it's been 9 months since its enactment, which was July 1st, 2025. So, right when that happened, I made a series of predictions. In fact, a lot of competent HOA lawyers made a series of predictions, and those predictions have all come true.
They have, indeed.
And we talked specifically, and we make a point of competent HOA attorneys because there's that professional promoter we routinely talk about on this podcast and that I've covered extensively in writing as well, who by virtue of AI or combination of AI and the rise of and the power of pay-per-click advertising on Google is able to spend tremendous amounts of money and spew out garbage, basically garbage podcasts actually, and garbage articles full of legal mistakes and errors, and yet command this false expertise position because people don't know the difference. So that's the only competent lawyer that I've met, either on the HOA side or the homeowner side, who's actually championed AB 130 as being this great panacea. And the funny thing is this professional promoter even implied very strongly in multiple articles and podcasts of his, even filming in Sacramento, that he had something to do with its passage when he had nothing to do with it. Nevertheless, we're going to talk about being 9 months in from AB 130, the predictions, and how we're seeing how those predictions that I made have manifested in real life at our firm. Because we can only comment on what we're hearing from comments or from our discussions with other lawyers in this field about what's happening at their firm. So we'll cover those as well. Okay.
Sounds good. Okay.
I guess today is we're going to cover where the paper meets the real world. Okay.
Yeah.
So let's start with prediction one. One of the first predictions I made was mass confusion.
Oh, yeah.
Okay.
That's huge.
The statute leaves way too many key terms. Undefined. Okay. Either undefined or undeveloped. In other words, either undefined, leaving it open to interpretation as to what is meant, or if it was seemingly an obvious word, then no limitation put on scope.
Correct.
Or even legislative intent isn't there because it was never debated. This thing was was created and stuffed in as a last-minute amendment to a budget bill.
Very short-sighted to those who are within this industry and do this for a living.
And so what we're now seeing is because of these undefined or lack of scope, open-ended use of certain terms, it's caused mass confusion. So, for example, we have homeowners that are repeatedly asking, can my HOA fine me every day or just once for the same thing? For example, and we'll give an example later, okay? If I don't fix it, is it one violation? If they tell me to fix something and I refuse, is it one violation or is it a multiplier? Okay? Can they keep sending me notices every day? Can I just ignore the HOA? What will happen if I do? So I pay the fine, that kind of thing. So even experts like us are guessing as to these issues. And the answers we have to give is statute doesn't address that.
Right.
There haven't been any appellate court cases yet interpreting that, so we can't know. We can only tell you what we think.
We say that, yet we espouse and position in ways that advances zealous advocacy. So
Right.
yeah.
Exactly.
Yeah.
And we had a situation yesterday in our office where we had a court make a decision in a case that, in my opinion, and I've been doing this for a long time, and I'm going to go ahead and brag a little bit because it matters. I'm considered one of the foremost experts on the HOA side of HOA law in California, on the homeowner side, not the HOA side. That's not what I meant. I'm considered one of the foremost experts on the homeowner side of HOA law in California. And I considered this to be what we call a slam dunk. The facts were quintessential violations of the Davis-Sterling Act by this board, and the judge just ignored the fact, disregarded the evidence that was actually introduced in the case, and ruled opposite of what every single lawyer that we've ever talked to, other than the insurance attorneys representing this HOA. Everybody, even on the HOA side, when I've talked to some people that we know that we're friendly with on the other side, who were like, I'm shocked this has gone this far. They knew that the law was on our side, and yet you never know what a court's going to do. So we have no idea what a court's going to do to interpret any aspect of AB 130. It is a crapshoot. But it hasn't been long enough yet for those to wend their way up to the appellate courts, which is where published decisions come from.
Right.
And so we have no idea. And so we have to tell our clients, here's our best educated guess.
We have an ethical obligation to tell them that at this point.
Yeah.
I mean, we know what we know, and it's our sense to, that we're going to argue it a certain way, but that's the extent of it.
Yeah. And we were cited, we were quoted in a couple of different newspaper articles, San Francisco Chronicle and the San Jose, I can't remember what
Mercury, I believe.
Yeah, San Jose Mercury. We were quoted, and we were giving the same opinions that other people were giving. Other competent lawyers were giving, I should say. I got to always go back to that. Competent HOA lawyers, because that excludes the professional promoter lawyer, who's a lawyer in name only because, he passed the bar. But, so they've asked us, one of the big questions they asked us, what does per violation mean? Because remember, AB 130's got a what cap?
Fines cap at $100.
$100 fine cap per violation.
Effective June 30th, 2025.
And it says per violation, $100 per violation. So I think it's a very smart question. What does per violation mean? Don't know. I can give you my best guess because the word per is not hard to define. PER, right? And violation shouldn't be hard to define. Those are common English words. So per violation should mean something, right? Yeah, not necessarily.
Yeah. Well, especially given the nature of violations in HOAs.
Yes. So let's put this in a real action. Let's talk about a real case because that's the best way. I always say this, right? It's the best way to learn. So let's talk about a real case. We had a client who made improvements to his balcony without HOA approval, okay? HOA issued a $100 fine. This is obviously post AB 130, right? So they issued a $100 fine following a hearing. Balcony was still there the next day, and the next day, and the next day. So they cited, let's say, and I'm making this part up because I actually don't remember. I wasn't handling this. But let's say it's a Monday. So he gets his violation letter on a Monday, right? And by the way, I went to the future because there was a hearing, and he was fined. But the first letter came on Monday, violation on Monday. And then another letter came on Tuesday, and then Wednesday, and then a couple came on Thursday because I guess it missed. I guess they mailed several at once or whatever it was, but they were going for every day. And the date for the violations was different on each letter. Okay? And in the past, what did I call that? Do you remember in my book?
Stacking?
Stacking,
yeah.
Right. That was one of my big fears.
Yeah.
Okay? So the HOA started sending separate violation notices every day, and they did it for 14 days, 2 weeks. The hearing date on each of the violation letters was the same date in the future, well within the, well beyond the 10-day, notice period, all that stuff, okay? And each of those letters talked about the separate violations for each day, separate violations. So clearly what this HOA was doing was saying, Monday is a violation, still there on Tuesday. Tuesday's a violation, still there on Tuesday or Wednesday. Wednesday's a violation, and they did that for 2 weeks. So Client wanted to know whether that was legal. So we get involved, okay? So we start explaining why this case was unique. It's unique because of how ambiguous AB 130 was in defining what a per violation was. And didn't address the obvious and completely predictable problem that would result. Because it's easy to say, okay, somebody has their trash cans out too long. You bring them to a hearing, you fine them. The trash cans don't stay forever. They eventually get put back and they get brought out the next week. If they leave them out again, it's not a difficult thing to say, yeah, we're going to send you a new letter. It's a new violation. It's obvious.
Correct.
Because it was corrected in the interim, right?
That's right. Yeah.
But how predictable was it that somebody might build something they shouldn't build or plant something they shouldn't plant, and the HOA rightfully says, you never even give us an application. We don't even know if it was built safely.
Right.
Okay? So you got to tear it down or do an application retroactively, something. Okay? How predictable was it that somebody wouldn't do it, wouldn't listen?
Very predictable. Yeah.
And how predictable or how obvious is it that that's a very different scenario than an intermittent wrong or a wrong that occurs more than once but is fixed in the interim, like the trash cans or parking? Because unless you're leaving a car there indefinitely, even if you park illegally, chances are you're going to get in your car at some point and drive it away and then repark illegally. New violation. But this isn't that. It was totally predictable, right? Am I wrong?
Agreed. I would even go as far as saying you didn't need to consult with an attorney to come to that conclusion.
Okay,
It's common sense.
I'm not crazy, right?
Common sense, yeah.
Yeah, and yet the statute doesn't even spend a letter addressing that. Nowhere. Okay? Totally ridiculous. Okay, so we get involved and we explain to him, here's your problem. We don't know. Okay?
Yeah.
Now, obviously, you said it a few minutes ago, we're zealous advocates. We're lawyers. Our job, our legal system is what's called an adversarial system. It depends. It works because the lawyers for each side are supposed to fight out and argue and take positions, right? And so we're zealous advocates. And so we obviously will try to paint things the way we see them, right? But usually it's within the confines of some sort of structure, a statute, right? Here, the statute is so silent on some of these issues that there's no structure to look at. And intent's impossible because we know the intent. The intent, if the intent was we need to solve this problem with excessive fines in California, great, we agree. That was a problem, needs to be addressed. Our whole contention has always been, and correct me if this isn't yours, this is mine, my contention has always been not that excessive fines was an issue that need to be addressed. It was that AB 130 is the last thing that should have been done. It doesn't solve the problem. It just makes new problems.
Totally agree.
Okay.
Yeah.
So we argued that because the condition never changed, in other words, all that changed was the sun rose and fell and the moon came up and down, and each day it kind of happened again and again, right? And maybe weather, whatever was happening in the world, that's all that changed because a balcony, nothing changed. So it was one incident, one violation, just ongoing. That's the only argument we can take, right? In short, we argued that our client's HOA couldn't relabel the same condition as a new violation each day. We argued it was unreasonable. Now, I believe it is unreasonable, but I'm not blaming the HOA for making that. This is not a bad HOA. This is a creative HOA trying to work within the confines of a very badly written law. But my job, or our job, and I say my, and BK Chapman's job, is to help our client out of that situation. So we argued, ultimately, the HOA was entitled to a $100 fine. Now, and we'll get to this later, there is a remedy that the HOA is not just stuck. Give them a $100 fine and that's it. There is a remedy. It's just a lot more expensive, a lot more involved, and costs the whole HOA a lot more money.
True.
Another one of the big problems, which is why I don't want to repeat myself. We'll get to that later. So, were we correct? I think we were in that specific instance, but I don't know. Okay?
Yeah.
Nobody knows. And we won't know until
The law's too
trial
recent,
court decides it. It gets appealed. The appellate court rules about what per violation means. Once the court, and we're talking about the appellate court, publishes an opinion that says per violation within the meaning of 5855 or 5850, AB 130, whatever, means this, we don't know. Okay? So, and again, we're talking about one balcony, no change. It's the same thing. It's the same incident, just new days, right? But all the changes that did occur, all the things that are different each day, none of them are in our client's control. Our client's not God. So he doesn't control passage of time. He doesn't control the fact that Monday becomes Tuesday, becomes Wednesday, and the sun goes up and down and the moon goes up and down. He doesn't control any of that.
It's not even a case of an ongoing, continuing construction.
That's right.
The modification is already completed.
New nails are put in every day. That is different because there's new stuff.
Exactly.
Right. It's not. Nothing changed. Okay, except entropy. It gets dirtier. Right. Okay. So we pointed out the fact. And lastly, our argument was this. And the coup de grace on you guys, the HOA, was you set one hearing date far enough in advance, but for all of these, which tells us in your mind you considered it one violation, because otherwise you would have set separate hearing dates.
Yeah.
Anyway, in this specific case, the HOA backed down.
Yeah.
I think this was a tester, which is why they only did it for 2 weeks. I think this was a test to see what would happen. They backed off. They reversed the fines. They're still stuck in the same place, though, because they have to act because otherwise failure to enforce, right? They can't let a homeowner get away with that. We told the homeowner, by the way, if the HOA decides to take you to court, whether they go through ADR first or not, you don't have a defense.
Right.
You don't have a defense. You're going to lose. You violated the governing documents. It's clear as day. And this isn't an example of this wasn't a selective enforcement issue. There's none of these other defenses that might normally be there. This was clean. Okay, this HOA wasn't what I call a bad HOA. It was pretty reasonable, which is why they backed off. Bad HOA wouldn't have backed off. Bad HOA would have called the bluff and said, spend the money. Okay, so what are we left with? We're left with no definitive guidance is what per violation means, and we're going to be dealing with a lot more of those scenarios that may or may not end as cleanly as this one did. So that person rides off in the sunset to face the problem another day because the HOA can't not act.
Exactly.
Anything to add on that example?
No, the HOA, it's just a matter of time. Exclusive use common area, the HOA will act.
Okay. Yeah. So I'm going to let you talk about the second prediction I made. Second prediction I made was that a lot of homeowners would, and don't get into the consequences for this. Again, that comes later. But a lot of homeowners made the business decision. They said, well, I'll just pay the $100 as a cost of doing business.
Right.
Tell me about that and how it's manifested.
Well, the instance you're referring to in the prediction, it's exactly right. And we see this manifest in instances with actual clients, potential clients, and it's already happening, where these homeowners essentially knowingly, they are aware that what they're doing, the conduct they're engaged in, or let's say the unauthorized modifications or changes they've made to a certain component, without prior HOA approval constitutes a violation or runs afoul of rules and the governing documents, specifically use restrictions. Yet they knowingly and deliberately engage in it, knowing that the consequences of AB 130, as of mid last year, is merely $100. The fines are capped at $100.
And even worse, some of these people were in the midst of addressing things when it went into effect and then abandoned the reasonable interactive process.
We've discussed that in prior episodes that you referred to, where we had actual clients and they said like, oh, nope, I'll take the cost of doing business, even though we alarmed them to the potential foreseeable consequences, which we'll talk about. And so in these instances, they will essentially deliberately choose to proceed and remain in noncompliance. And in their view, the deterrence is not strong enough, and they'll just kind of kick the can down the road.
And we're not talking about the unreasonable or the over controlling rules that we are against, and we would kind of behind the scenes be championing them, like fight the power kind of thing, right? No, these are actually rules that exist for a reason, and they're reasonable rules,
right?
And yet everybody else follows them, but not these people. I have a problem with that. That bothers me.
I mean, a big one is the nuisance provision that 99.9% of HOAs have in some form, and there's also a private right of nuisance, not to get it too many
I'm just going to keep playing I'm going to have my drum sessions every Saturday night till 11 o'clock. I don't care.
Yeah.
Because it's worth $100 a week for me to do that.
Exactly.
Because I hate my neighbor and I get the drum practice. Whatever it is. I mean, I'm being facetious there, but yeah. So let's talk about a real example, though, okay? So a lot of people have talked about that. Hey, HOA fines are capped at $100. So, I'm just gonna see it as a cost of doing business. There are a lot of problems with that. Okay, one is repeat enforcement. Like the example we talked about above. If your HOA is one of those ones that's going to, and by the way, remember, it might have been a different, we don't know, we are not the courts, but it might be a different situation if you do have different hearing days, right? As opposed to lumping them all.
Good point.
So what if another HOA did the exact same thing, but this time sent a new notice every 2 days and with a new hearing date, just stacking them up,
Or
right?
what if you had different complaints for each instance?
Right, exactly.
Yeah.
So you've got repeat enforcement, you've got, and we're going to talk about this, litigation exposure. This is what a lot of good HOAs, remember we talked about the good HOAs, bad HOAs are going to violate the rules and twist things. We're going to talk about how shortly. Good HOAs are going to do one of two things. They go one of two ways. They either go in the direction of, because they don't want to violate the law and they don't want to get caught up in a situation where they're going to end up owing attorney's fees and costs, they do nothing.
Yeah.
Or they skip the whole, I don't know what's going to happen, so we're not even going to go in that direction. We'll just go right into demanding ADR and then filing a lawsuit for injunctive relief.
Yep.
Okay?
Let's mediate. Yeah.
Mediate, because that is a requirement if you're just seeking injunctive relief. So you got to mediate first and then boom. Okay? And we'll get into that, why that's a big problem. But the homeowners that are taking this business first type thing, this I'll take the penalty, are ignoring the fact that eventually the good HOAs are going to cotton on to skipping this whole process that used to never end up in a lawsuit and just, you're going to get, here's our demand for ADR, right? 5930 et al., all that stuff. And then we're suing you. Unless, because all we're going to accept is complete capitulation from you. Okay? So let's do a real life example. Again, those are great. So we had a PC, okay, potential client that applied to his HOA to install a new front door. Okay. The HOA previously denied the application. I'm sure you remember this one. Denied the application because the front door that he wanted did not conform to any other front door. Right. This one was glass and metal, and nobody else had it. It wasn't, again, no selective enforcement here.
Very contemporary, yeah.
It was all like old school wood, oak looking.
The rest of the community.
Right. Okay. None of them. All right. Now, July 1st of this year comes around, and instead of continuing with changing the door and finding a conforming door, this PC decided to take that approach we just talked about, which was cost of doing business, installs the front door, gets a hearing notice, shows up at the hearing, the HOA listens, and then fines him $100. He pays $100. Okay? Now, this HOA didn't do the multiple notices thing that we talked about at the beginning. Didn't do any of that. Now, HOA then sends a formal ADR demand. Follow within the confines or within the meaning of the Davis-Sterling Act. So this is a precursor because they announced that they were only going to be seeking one cause of action, which was injunctive relief. And remember, under the Davis-Sterling Act, if either party is seeking injunctive, writ, or declaratory relief, or a combination of one or more of those in conjunction with money damages of less than $12,500, ADR is required. Otherwise, it's not. Contrary to what the bad HOA lawyer we talk about put in his book, he's just wrong because not ADR is not required in all HOA cases. They're only required in enforcement actions that seek one or more of those three causes of action, or one or more of those in conjunction with money damages of less than $12,500 or $12,500 or less, I should say.
Yeah.
Okay, so he got that letter, and it had a copy of the draft lawsuit that they were going to file.
Yeah,
he came to us at that point. We looked at it and we said, "Remove the door. You're going to lose. There's no defense here. You have no chance. There's no argument here about selective enforcement. There's no argument here about under the business judgment rule, the HOA is within their power to say no to this door. Okay, you don't have a defense.
His payment of $100 at the hearing or post-hearing does not preclude them from taking further steps.
No.
Yeah.
They took further steps because he was fined and didn't do anything.
Correct.
Instead of trying to redefine per violation or come up with their own to try the tricks that the first HOA tried, this HOA just did what I predicted would happen. Is it would result in a lot more starting the ADR process as a precursor to starting litigation. So we told them, take the door out. You have no other option. Well, can't I pay you? You're going to pay us 6 figures if this goes all the way to trial. Yeah. And this will, because this is an important issue. It's going to have to be tested here. So this is one of the ones that might actually go all the way, right? You're going to pay us to lose, and you're going to have to remove that door. So no, we're not going to do that. We're not going to take your money. Mm-hmm. We won't represent you if you insist on litigating. Point is, we convince this person remove the door, problems are solved. Okay? That's the real life example. Prediction 3, good HOAs would pull back from strict enforcement. Now, am I wrong about this, Sam? Isn't one of the main fundamental duties of an HOA to enforce the governing documents?
It absolutely is.
Okay. I thought I read that somewhere. Perhaps in the Davis-Sterling Act.
Yeah. There's certain qualifications.
I'm being facetious, but yes.
Exactly, yeah.
That's in the Davis-Sterling Act. Mm-hmm. So I predicted that good HOAs, as a result of AB 130, would do the opposite. They would pull back from enforcement. And there's good reason why. They don't want to be officious. A good HOA doesn't want to violate people's rights, and they also don't want to risk getting screwed by a court and labeled as a bad HOA and having the hammer come down on them. Mm-hmm. So they do nothing. They're going to just wait and see what happens.
Or they don't want to cause hardship to the rest of the membership.
That too.
Yeah.
It could be a lot of reasons, right? Mm-hmm. So what we're seeing is I was right.
Yeah.
Okay? So let's talk about how that manifested in real life. I don't know if you remember this. Do you remember this case with the neighbor-to-neighbor dispute involving the privacy?
Was it a camera issue?
Yes. Yeah, the privacy violations.
Vaguely, yes. Uh-huh.
Do you remember it enough to talk about it, or do you want me to?
I think you ought to go to it. Okay. You have the notes, I see.
So we had a client who hired us because his neighbor was absolutely violating California's privacy laws. Mm-hmm. Because of the cameras, one or more of this neighbor's cameras were actually pointing like one of them was pointing into our client's yard or pool.
Oh, that's right, yeah.
And it was obvious, and we had a way of showing that. There was technology you can do to actually look at a lens, right? So he was able to show that. And a couple of his other cameras were seemingly pointing into bedroom windows in the upstairs, stuff like that, okay? Where it's just obvious it's not pointed down toward that guy's property. Mm-hmm. So HOA, doing the right thing, sent a demand, because that violates nuisance, right? Mm-hmm. Mm-hmm. Sent a demand to this homeowner demanding removal or repositioning, either one, of the camera, which is the correct solution to this, right? And they sent a violation letter and called the perpetrator to a hearing.
Yeah.
Perpetrator didn't show. Okay. So the HOA showed, and they fined this homeowner in absentia. Okay.
Mm-hmm. Yep.
Fine him $100 for the violation.
Which they can do. Yeah.
Which they can do.
Mm-hmm.
Now, the homeowner paid the fine, but didn't do anything with his camera. Sounding familiar? It's sort of like the door example, right?
Yeah.
Okay.
Some of the same patterns. Yeah.
It's the same pattern.
Yeah.
Okay. So the HOA's counsel, this is the attorneys that represent the HOAs, told our clients that they couldn't keep, that their lawyer told them. So, I'm sorry, the HOA's counsel did. The HOA's counsel told the HOA that they couldn't keep fining because it was the same violation. Mm-hmm. Okay. And so they said, this is what our HOA lawyer is telling us.
Yeah.
And they are listening, rightly or wrongly, they're listening to their HOA lawyer. And our only other option would be to sue, and we're not willing to do that for this. Which leaves our client in a very difficult place, because our client has the right to enforce governing documents. Our client could sue the neighbor, right? That's easy. That's a slam dunk. Mm-hmm. They could sue the neighbor, no problem. Okay. So we got involved and we sent ADR demand out.
Yeah.
But we sent it to both the neighbor and the HOA because we want the HOA to do its duty.
Correct.
We want you to enforce the governing documents. Now, we sent that knowing that we were putting the HOA in a difficult position given AB 130. Hence, another big problem. There are HOAs out there that want to do the right thing. There are good HOAs. I say this all the time. You could tell a lot about a lawyer's credibility. If you have a homeowner-side lawyer like the professional promoter who never has met a reasonable HOA, you know that there's no credibility there.
Agreed.
I've never heard this person say anything positive about an HOA. That's not possible. There are good HOAs. There are just a lot of bad ones, but there are good ones. And if you can never recognize a good one, you have no credibility.
It's incredibly important to distinguish between those two.
That's right.
And you'd be doing your clients a disservice or potential clients.
And that's why the professional promoter is actually a laughingstock in the industry. If you talk to any of the big 10 HOA side law firms, the lawyers there, they pass his stuff around as a joke. They literally pass his book around and his articles around, and they slack and tweet the mistakes. It's actually very funny. We've got, you used to work on that side. You've gotten some stuff from people you knew in the back in the past. It's very funny. But anyway, so we sent ADR demands out to both, and obviously there was no dispute. There's a violation of the nuisance provisions and the governing documents, and by the way, California's statutory privacy laws as well, and common law, right? And the HOA attorney, I don't remember, you didn't handle this, but the HOA attorney actually told us, unofficially, we agree with you. This neighbor's inappropriate. It's just wrong. And I remember being told by the lawyer that works for us, they actually talked about AB 130. That was part of the conversation. Anyway, they advised their client, the HOA, that nobody could predict what was going to happen here.
Yeah.
And that, or how a judge might rule. And so unless the HOA is willing to gamble their way, going out of the way and spending hundreds of thousands of dollars to litigate this, it was better if they stood down. So that's what they did.
Yeah.
So what's the result? Pending. Okay. We are in process right now. I think there's a mediation coming up. I don't think the mediation has happened yet because that was very recent. But again, this was all predictable. Okay.
And perhaps avoidable if the legislature had done
100%
its utmost due diligence.
Right.
Yeah.
Prediction 4, costs will go up. I predicted that AB 130 will result in dramatically increased costs for HOAs. I've been correct. So we're seeing evidence of that. Give me a couple of examples of costs going up in different avenues.
Well, examples are that HOAs, because they're now hamstrung in terms of not doing repeated fines, staggered fines, what they end up doing is end up incurring additional time and strains on their resources by virtue of management having to send multiple letters and notices, lawyers having to consult and provide legal opinions and recommendations, them having to serve, like the example you just gave, ADR demands, requests for resolutions to mediate. So all of that in the aggregate adds considerably in terms of cost, and oftentimes it's cost prohibitive to take actions beyond those steps. And
think about this. We've talked about this. We talked in a couple of recent episodes, and definitely in fact sheets on my website of the Fannie Mae Freddie Mac issue.
Oh yeah,
and the delisting.
That's
and if a neighborhood, if a community is delisted, that means that Fannie Mae Freddie Mac will no longer back those loans. That means you're not selling your house except to a cash buyer. Okay. Yeah. That's a devastating finding. That is devastating.
It is.
Unless you find an investor, an all-cash investor or buyer, you're not selling your house if people can't get a conforming loan, right?
That's
a backed conforming loan.
Yeah.
And so, as you know, you pointed this out before, when the amount of unpaid assessments or fines passes the threshold percentage, and I can't remember off the top of my head, it's 10 or 15%, right? They get delisted. The HOA gets delisted.
Correct.
And you're seeing, in our examples today, the people paid the $100 fine, so not an issue. But you're seeing a lot of stubborn people that don't know about the no offset rule, and they're not paying.
That's right.
They just ignore the HOA.
Yeah.
Well, that percentage goes to a certain point. So we're seeing insurance companies now raising rates or canceling policies. I don't know if I've seen a cancellation. I've seen rates going up for this issue.
Okay.
Okay? Or tied to this issue, at least in part.
The delisting of Fannie Mae, Freddie Mac?
Or the
default rates going up.
The default rates.
Oh, yeah.
I don't know if it's tied to Fannie Mae, Freddie Mac.
And keep in mind, it's also a ripple effect in terms of, as that's happening, there's less money coming into the coffers of the HOA, so there's going to be ripple effects in terms of failure to maintain or replace components.
There should be, because fines aren't supposed to be a revenue source.
On the special assessments for, let's say, litigation costs and things of that nature.
I wasn't even going there.
Okay.
Well, that's the next one.
Right.
For the HOAs that are choosing to enforce and sue, remember, HOAs have insurance. They better, right? And so when they're sued for violating governing documents or whatever, the insurance company kicks in and comes in and provides the defense, and that's great. So the homeowners don't get all these special assessments.
Right.
But when an HOA is suing, there's no insurance to cover the prosecution of a lawsuit.
Exactly.
That is almost always going to be either out of their coffers or a special assessment or both. Meaning, every time the HOA has to sue, you're going to pay for it one way or another. Okay? Either directly by a special assessment or indirectly in increased dues. Or more money going to pay for that means less for upkeep, maintenance, replacements of common area components, which eventually cost you money in the future. So it's all related and you're going to pay. One way or another, you, the homeowner, are paying to sue Sally and Mary and John because they are violating governing documents and don't care.
Right.
Okay? So we're seeing that.
Yeah.
Okay? That also has, even though insurance isn't being used to pay, insurance pays attention to that.
Right.
And it makes it more expensive to cover the directors.
Exactly.
The E&O coverage, it is required,
Yeah.
becomes a little more expensive.
And the pre-litigation costs. I mean, all these attorney correspondence between the board, management, and their legal counsel, and then the ADR demands. I mean, those are voluminous in most of these HOAs.
So we're seeing these increases from just costs, litigation related, pre-litigation, insurance, all costing homeowners more money. It's now coming to fruition. I predicted it. It's happening. By the way, I'm not the only one that predicted it. Intelligent, competent HOA lawyers on both sides predicted this. The only ones that didn't were the dumb ones that we've talked about, the pretenders. Okay? Now, prediction 5, bad HOAs and bad members benefit, while the opposite happens to the good HOAs and the good members. We said at the beginning, and you agreed with me, that AB 130 would reward bad HOAs and bad homeowners. It would reward bad HOAs who don't follow the rules anyway. That's why they're bad HOAs. And they're going to find an end run. They're going to find a way to do an end run around the rules anyway. And bad members are the ones that take advantage of these lapses or fears of enforcement or these loopholes in the law or these uncertainties. They take advantage of that so that they get away with stuff that their neighbors don't do, and that's not fair to everybody else. That's the bad HOA. So bad HOA members are constantly pushing boundaries, knowing that if they live in a good HOA, but they're a bad member, knowing that they're taking advantage of their HOA's unwillingness to file lawsuit after lawsuit after lawsuit, right? Bad members are taking advantage of the hesitancy and of the loopholes. And bad HOAs are, and this is where we're going to get into what I consider to be a very, what's the word I want here? It's subtly evil. It's so dishonest. Maybe that's better. They're interpreting ambiguities in the law in their favor. I get that. Everybody would do that, right? But they're also redefining very common English words to mean something completely different as literally an intentional end run around the law. Not a good faith argument as to a reasonable person could interpret the statute to mean this. No, I'm not talking about that. In ambiguities, differing interpretations can be reasonable. We're not talking about that. We're talking about changing, basically saying a blue sky could actually mean a gray sky also. We're talking just bald-faced lying.
Right.
And we're going to talk about that because that's where we're at now. And I'm going to reserve that example for this next one. Okay. So I'm going to go on to prediction 6, and then I'll give that example.
Good.
And one of my other predictions, if you'll recall, prediction 6 was remember the health and safety exception? So $100, Sam answered at the beginning of the show, $100 cap on fines, except in the cases of health and safety. Now, AB 130 amended a few statutes in our Davis Sterling 5850, 5855. And in AB 130, there was this, it talked about the health and safety exception, and then it gave some requirements that the board has to follow to utilize it. So you can't just, health and safety exception and boom, fine them $1,000. No, you have to have put into the record what you're finding is a health and safety violation and why. Basically the basis for it, right?
Exactly.
So you got to put that into the minutes. You got to include that into the record. Okay? So I predicted that bad HOAs, good HOAs would be confused and might step back and do nothing because they're not sure. And bad HOAs were going to take advantage of that in some way, right? I said that they were somehow going to misuse or abuse that ambiguity. So health and safety was partially kind of defined in the statute, at least to the meaning was intended, but what they didn't discuss was its scope.
Exactly. Yeah.
What they didn't even give any examples. For example, this would constitute health and safety, blah, 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 right? Now, when we read that, you and me, we think of the obvious things, okay? You have a balcony that's dangerous and the person's refusing to fix it. Okay, we can now really go after you.
Yeah.
We can start finding you like crazy because it's right? Or mold issue, right? You leave your bathtub on while you're gone in a movie and you get home and you flooded the neighbors below you, right? And you won't take care of the mold or won't do anything. Health and safety, right?
Hoarding, pest infestation.
Very good.
Yeah.
Yes,
Yeah.
we get we've had those cases. Okay, so what we're seeing bad HOAs doing now, and this is where we'll talk about the example, is the twisting the meaning of health and safety to reframe things that have always been normal violations into health and safety violations just to avoid the cap. In other words, you've got some HOAs are reclassifying violations that never implicated any health and safety as now implicating health and safety. So I'll give you an example. There's 2 examples we've seen. There are probably a lot more, but these are the 2 that I have seen. One of them we saw through a PC that came here. Another one actually was speaking with another homeowner-side lawyer from another law firm. Okay? An ordinary noise-related complaint. Okay? Loud music, whatever. Okay? Very annoying, very punishable. It's a nuisance, right? But we have seen a few bad HOAs reclassify noise complaints as now implicating health and safety because lack of sleep and the stress caused by lack of sleep does have a measurable, according to certain studies, a measurable effect or increase in the amount of heart attacks. Okay, and stress-related, strokes, right? So heart attacks and strokes do go up, and there's a direct tie between lack of sleep and stress causing increased heart attacks and increased strokes. And so suddenly it's now health and safety. That is such garbage. That is so manifestly dishonest. Okay, and yet
for those purposes, yeah, exactly, yeah. This is not an academic exercise. I mean, it's a very creative reasoning. There's a nexus.
I don't call it creative. I call it dishonest.
But it's a reach. It's an absolute.
It's not even. There's no nexus. The nexus is in the medical literature,
exactly,
not for a bunch of lay people to make that determination.
Yeah.
That's just BS. That is just a lie.
Right.
Okay. I have a worse one for you. This one's even better. I wrote a 2 or 3 part series just in the last week or so on the website, fact sheets relating to short-term rentals, okay, in California. STRs, right? You now have bad HOAs that are enforcing their short-term rental restrictions as health and safety related because of the increased transient occupancy and the unknowns, small increases in crime and vandalism.
Yeah.
That because of increased use and increased threshold of people that you don't know, that increase in potential for crime is now a violation of health and safety. There's no reasonable nexus. Okay? So the bad HOA is going to go ahead and pull this kind of crap, knowing that a homeowner that wants to challenge it, that's 1 in 100 homeowners, will care enough to challenge it and have the financial and emotional wherewithal to go in for the long haul. So bad HOAs go in knowing it. The numbers are on their side, and they're going to just outspend and make the person give up. We see it every day. It is such a bad faith tactic. They have no legitimate at all. They know it, and if they were under oath and there was a special machine that you couldn't lie to, like in Star Trek, okay? Yeah. You ask them, do you guys really believe this is a health? And they'll go, no. This is garbage. Yeah. But we're going to do it.
Right.
And we're going to do it because we think we'll get away with it long enough to make it worth it. Okay? If everything is twisted to become the exception, then the exception becomes the rule. That absolutely is not what the policy was designed for. Otherwise, there'd been no cap.
Right.
Okay? Prediction 7, financial commitment would create problems. You remember that one? The financial, you get out of your little hearing.
Right.
They've done everything right. The HOA did their thing. You did the crime. HOA does their thing. You go in, or beforehand, either before or at, and you talk about this financial. So you hand them what? What could you hand them that has kiboshed the whole scenario?
Well, you hand them essentially what's tantamount to a commitment to resolve.
A quote.
And like a bid. It could be from a contractor, et cetera. Yeah, a proposal.
I'll fix it. Here's a bid.
Yeah.
I had a contractor come out and give me a bid. Here's a bid.
Right.
Oh, yeah. Where's the contract hiring him? When's the start date? Oh, none of that's necessary.
Yeah.
The code doesn't require any of that. The code didn't say a signed contract with a start date within 30 days. Mm-hmm. Something like, if I were writing that law and I wanted to have that kind of out to lessen these things, I would have said, if the homeowner comes in with a definitive solution, such as a signed contract with a start date within 60 days of the hearing date, then bop, 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 bop. Right. That's what I would have done.
Yeah.
But I'm rational. Okay?
Yeah.
So who defines what's sufficient? Who can HOA challenge it? You give me a bid, which is nothing more than somebody came out and said, yeah, here's what I would charge. If you were going to hire me to do this, I would charge this. When are you going to start? Oh, I haven't decided that yet. Do you have a contract? No, I don't have one yet. Have you picked a contractor? No, I haven't. Can the HOA decide whether or not that's enough to, well, then, in our opinion, you have not given us sufficient amount? Can they decide that? Code doesn't say. Code doesn't say whether or not, if they did decide, they were correct. The court could come back and say, well, no, he gave you a bid and that's enough because the legislature didn't give any specifics. So one judge might say, I'm doing a strict reading and it doesn't say so. If they meant to say, they would have. So I'm fighting against you. Another judge who doesn't like that result would say, well, I think that's what they meant. Yeah. Okay. And they just make it up.
And a reasonable argument could be made that that homeowner, in their utmost good faith, wanted to have a face-to-face or meet and confer with those board members, get some feedback before they made a commitment beyond that. Right. So the code, AB 130, could have really helped the situation just by giving some benchmarks. One, maybe two. Yeah. Something simple. Mm-hmm. Okay. Before we hit our closing, are there any specific consults that you've had that you might want to share? I think in terms of the overall tenets and the repeating patterns, I think we've touched on it by way of illustrating through those examples and hypotheticals. I think a lot of the nuisance-related ones and the abuse in terms of the health and safety, those have come up repeatedly.
A lot, yeah.
So,
and you're seeing them all the time.
We see them routinely. We absolutely do.
I know for a fact you see the $100 cost of business one every week. And you now have a mantra that you give about careful because that.
No, we always caution them in terms of, look, this is not the end all be all. This is just
they might
one
just
little
skip the
facet
finding.
of it. Yeah. And for those who are well informed, they can appreciate the downrange effects of if they simply treat it as a cost of doing business, because they now know, and they'll certainly have important guidance and some substantive information, as well as a bit of an education through these consults where we'll send them
home with a copy of a fact sheet that I've written on that talks about that very issue.
And for the overwhelming majority of those reasonable folks we meet with, they, by the end of those meetings, will fully appreciate the potential risk of exposure that they have.
Right. Now, let's be clear. We're not talking right now about HOAs are doing things illegal. We are very good at holding those guys accountable. That is one of our favorite things in the world to do. It's why we love what we do. Okay? We're talking about these good HOAs and where the homeowner's in the wrong.
Yeah.
If we have evidence of selective enforcement, if we have evidence of an unreasonable rule that doesn't pass the reasonableness test, if we have evidence of breach of the gross negligence or wrongful conduct that would negate the business judgment rule, we go after those HOAs and we say, we tell our clients, pay the fine or pay the assessment because remember, there's no offset. Pay that. But I wouldn't comply. Mm-hmm. Don't tear the thing down yet. You're trying to put the front door or the metal in the thing and you have 80 houses and 20 of them have the same door. You keep it in there. Mm-hmm. Pay the assessment or the fine, but keep the door there. Don't tear it in. We'll take them to court. We'll do that all day long. We're talking about the situation where the HOA is not wrong.
Yeah.
Or where we can't in good conscience tell our client to ignore.
Right.
We don't think we can win.
And by the way, in cases where it's rather obvious and blatant that, the folks we meet with, that they're in the wrong,
we tell them.
And we not only do we tell them, but there's also, in addition to the HOA, a point of exposure from neighbors.
Yeah.
Right? Yeah. Neighbors can come up.
Remember, we sued the neighbor or we've done the ADR demand on the neighbor and the HOA. And if that doesn't settle, we'll sue both.
Yeah.
Okay. Now, so we're 9 months in from the enactment of AB 130, and what have we seen? Confusion that I predicted, happening. Okay. Hesitation by good boards to act, happening. Shift towards litigation and skipping the entire fining process to avoid the problem we were just talking about, happening.
Yes, it is.
Costs going up, whether through assessments, general, or whether through special assessments or increased insurance or all of those.
Absolutely happening.
Happening. Okay. Abuses by bad HOAs and bad members by redefining or counting on weakness or shyness of a board to do something, happening. Everything that we predicted is happening. And it will continue happening. And at some point in the near future, things will go to trial. It'll happen a certain way, and somebody will appeal. It'll go to the appellate court. And then in a couple of years, maybe we'll start getting some more definitive responses that we can then do another podcast episode and say, okay, the first case just came down. And now we've got some guidance on what the health and safety exception really is, what the scope of it is. But that's a couple of years off, at least.
Yeah.
Okay, so until that happens, if you like this episode, please hit the like button. If you haven't already done so, please subscribe to the channel, HOA Hell. If you want to leave a comment, please do so. I answer as many of them as I can. Until next time, have a wonderful day.